Okay, this is some literary warm-up called What My Father Wore. For the record, what my father wore embarrassed me as a young man. I wanted him to dress like a doctor or lawyer, but on those muggy mornings when he rose before dawn to fry eggs for my mother and me, he always dressed like my father. We lived in South Texas, and my father wore tattered jeans with the imprint of his pocket knife on the seat. He liked shirts that snapped more than those that buttoned, and kept his pencils, cigars, glasses, wrenches, and screwdrivers in his breast pocket. My father's boots were government issued with steel toes that made them difficult to pull off his feet, which I sometimes did when he returned from repairing air conditioners, his job that also shamed me. But as a child, I'd crept into his closet and modeled his wardrobe in front of the mirror. My imagination transformed his shirts into the robes of kings and his belts into soldiers' holsters. I slept in his undershirts and relied on the scent of his collars to calm my fear of the dark. Within a few years, though, I started wishing my father would trade his denim for khaki and retire his boots for loafers. I stopped sleeping in his clothes and eventually began dreaming of another father. I blamed the way he dressed for my social failures. When boys bullied me, I thought they'd seen my father wearing his cowboy hat but no shirt while walking our dog. I felt that girls snickered at me because they'd glimpsed him mowing the grass in cutoffs and black boots. The girls' families paid men, and I believe better dressed ones, to landscape their lawns, while their fathers yachted in the bay wearing lemon yellow sweaters and expensive sandals. My father only bought 2 suits in his life. He preferred clothes that allowed him the freedom to shimmy under cars and squeeze behind broken Maytags where he felt most comfortable. But the day before my parents' 20th anniversary, he and I went to Sears, and he tried on suits all afternoon. With each one, he stepped into the mirror, smiled and nodded. Then he asked about the price and reached for another. He probably tried 10 suits before we drove to a discount store and bought one without so much as approaching a fitting room. That night, my mother said she'd never seen a more handsome man. Later, though, he donned the same suit for my 8th grade awards banquet, and I wished he'd stayed home. After the ceremony, I'd been voted Mr. Citizenship of all things. He lauded my award and my character while changing into a faded red sweatsuit. He was stepping into the garage to wash a load of laundry when I asked what even at age 14 struck me as cruel and wrong. Why, I asked, don't you dress nice like my friends' fathers? He held me with his sad, shocked eyes and searched for an answer. Then before he disappeared into the garage and closed the door between us, my father said, I like my clothes. An hour later, my mother stormed into my room, slapped me hard across the face, and called me an ungrateful little twerp, a phrase that echoed in my head until they resumed speaking to me. In time, they forgave me, and as I matured, I realized that girls avoided me not because of my father, but because of his son. I realized that my mother had slapped me because my father could not, and it soon became clear that what he had really said that night was that there are things more important than clothes. He'd said he couldn't spend a nickel on himself because there were things I wanted. That night, without another word, my father had said, "You're my son, and I sacrifice so your life will be better than mine." For my high school graduation, my father arrived in a suit he and my mother had purchased earlier that day. Somehow he seemed taller, more handsome and imposing, and when he passed the other fathers, they'd stepped out of his way. It wasn't the suit, of course, but the man. The doctors and lawyers recognized the confidence in his swagger, the pride in his eyes, and when they approached him, they did so with courtesy and respect. After we returned home, my father placed the suit in the flimsy Sears garment bag, and I didn't see it again until his funeral. I don't know what he was wearing when he died, but he was working, so he was in clothes he liked, and that comforts me. My mother thought of burying him in the suit from Sears, but I convinced her otherwise and soon delivered a pair of old jeans, a flannel shirt, and his boots to the funeral home. On the morning of the services, I used his pocket knife to carve another hole in his belt so it wouldn't droop around my waist. Then I took the suit from Sears out of his closet and changed into it. Eventually, I mustered the courage to study myself in his mirror, where, with the exception of the suit, I appeared small and insignificant. Again, as in my childhood, the clothes draped over my scrawny frame. My father's scent wafted up and caressed my face, but it failed to console me. I was uncertain, not about my father's stature. I stopped being an ungrateful little twerp years before. No, I was uncertain about myself, my own stature, and I stood there for some time, facing myself in my father's mirror, weeping and trying to imagine, as I will for the rest of my life, the day I'll grow into my father's clothes. Okay, these are some final instructions for the record. Ladies and gentlemen of the jury, you have been shown a number of summary charts and other demonstrative exhibits. Please keep in mind that these charts and exhibits were used mainly as summaries of testimony and documents that were presented in this case. The charts and exhibits act as aids for you in examining what is going on in the courtroom. They are not, however, evidence in and of themselves. They are demonstrations, sometimes graphic in nature, of evidence. The weight that you give to it determines the value and significance of the rest of the exhibits. To that extent, these exhibits do conform to what you determine the underlying facts to be in this case, and you should accept them. To the extent that these exhibits may differ from what you determine the evidence to be, you may reject them. Ladies and gentlemen of the jury, you should not be concerned about whether or not the evidence is direct or circumstantial. Both types of evidence are proper and correct for your consideration. Neither type enjoys preference over the other in the eyes of the law. Direct evidence is the testimony of one who has actual knowledge of a fact. This includes eyewitnesses. Circumstantial evidence is proof of a chain of facts and circumstances that tend to prove or disprove a fact that may be in dispute. Circumstantial evidence is sometimes called indirect evidence, which means it is not direct in nature. Now, if you recall, ladies and gentlemen of the jury, at the beginning of the trial, I gave you an example of an eyewitness's statement that said the following: "It's snowing." This is direct evidence. Now, this is opposed to observing signs from which a conclusion could be drawn that it is snowing outside. That would be circumstantial evidence. In assessing circumstantial evidence, ladies and gentlemen of the jury, you should use your reason, common sense, and experience to infer from established facts the existence or non-existence of another fact. You should consider only the evidence. but you are permitted to draw reasonable inferences from testimony and exhibits as you believe are justified in light of your everyday experiences. In other words, you may make deductions and come to conclusions that reason and common sense lead you to learn from the facts that have been established by other evidence. Now, ladies and gentlemen, an inference is a deduction or a conclusion that reasoning and common sense prompt someone with a reasonable mind to draw facts that have been proven by the evidence. You must remember that not all possible conclusions are fair inferences, and they should not become an inference unless you feel it is a legitimate inference. The law makes no particular distinction between the weight you give to either direct or circumstantial evidence, nor does it make a distinction between reasonable inferences that you may draw from direct or circumstantial evidence. You must consider all of the evidence that is presented to you, ladies and gentlemen, here in this courtroom. You must look at it and weigh it and evaluate it. You do not have to accept all of the evidence as true and accurate. You must decide whether you believe what each witness said. You must decide how important each witness's testimony is. In making that decision, you may believe or disbelieve any witness. You may believe all of a witness's testimony or part of it. You must not take into account the number of witnesses who are called to testify by one side or the other. In deciding whether or not to believe a witness's testimony, you must ask yourself several questions. Did the witness appear to be telling the truth? Did the witness have any personal interest in the outcome of the case or a case that is related to this one? Did the witness seem to have a good memory of the events relating to the case? Did the witness have the opportunity and the ability to observe carefully and accurately the things about which he or she testified? Did this witness appear to understand the questions clearly? Was the witness able to answer the questions? Did the witness's testimony differ from other testimony presented here in the courtroom? Did the witness seem to be candid and forthright? Did you notice a difference in demeanor or storyline when the witness was taken on direct examination as opposed to cross-examination? Was the witness's testimony consistent? Did the witness's testimony contradict or conflict with another witness's testimony about the same facts? Did the witness appear to have personal knowledge about what he or she was talking about? These are just some of the kinds of common sense questions you should ask yourself in order to decide whether or not a witness was truthful while on the stand. You may ask questions during your deliberation process to clarify or update a situation if need be. Ladies and gentlemen of the jury, the weight that you give to each witness's testimony should not be affected by prejudice, bias, or some other motive. You should also ask yourself whether evidence was offered that tended to prove that a witness testified falsely concerning some important fact. You should also consider whether evidence was offered that was different from the testimony he or she gave before you during the trial. You may also consider a witness's inaction that is inconsistent with his or her courtroom testimony in order to determine the witness's credibility. Ladies and gentlemen, this is not an easy task, nor did counsel or myself say it would be an easy task. You should keep in mind that a simple mistake by a witness does not necessarily mean that the witness was not telling the truth. People naturally tend to forget. People make misstatements. Some people have lapses of memory or tell an unintentional falsehood. If you find that a witness has testified falsely as to any material facts, or if you find that a witness has been previously untruthful when testifying under oath, you may reject that witness's testimony in whole or in part. or you may accept those parts that you believe are truthful or that are supported by other independent evidence in this case. Remember, ladies and gentlemen of the jury, you are the sole judges of the credibility of the witnesses. Okay, this will be some congressional material for the record. Mr. Speaker, today I would like to introduce some much sought-after legislation that is the goal of several factions in the economy. These factions include members of both the private and the public sector. This legislation proposes to lift the burden from the shoulders of America's crude oil royalty owners. This tax has been deemed by many of my distinguished colleagues as unfair and unequitable. In light of today's economic situation, I think you would find few people who disagree with that point of view. My bill proposes to exempt royalty owners and independent oil producers from the windfall profit tax. The windfall profit tax applies to the first 1,500 barrels of daily production of oil. My proposal is that the exemption go into effect immediately. The current application of the windfall profit tax has been misused and has incurred a severe burden on oil producers throughout the country. Many of my distinguished colleagues are probably not even familiar with the windfall profit tax. Unless you are from an oil-producing state, the importance and the serious burden of this tax have probably escaped your attention. And so we ask ourselves the question, what is the windfall profit tax? This point should be made perfectly clear to Congress at the outset. The windfall profit tax is not a tax on the excess profits of the large oil-producing countries, or should I say companies in this case. The windfall profit tax is an excise tax on domestic crude oil production. Congress has seen fit over the years to vary the percentage of this tax at whim, not allowing the oil companies any latitude for planning production and distribution and/or price increases or reductions. The windfall profit tax does not allow for any stabilization of oil prices to the general public. Congress should encourage the production of domestic crude oil. We should be encouraging the building and growth of America rather than the building and growth of some foreign country. We have learned that the countries in the Middle East are in a constant state of turmoil. The Gulf War played havoc with oil prices and with the supply of crude oil throughout the world. We cannot continue to be at the mercy of another country for our supply of oil. If we recognize the problem now and solve it, we will eliminate stumbling blocks in the future. We have watched while the countries in South America and in Central America have gone through various stages of revolution. This turmoil to the south of us also affects supply and demand and the production of oil. While the independent Soviet states, now planning to become major importers of energy, we must become self-reliant to ensure that our supply for the American people is there and readily accessible at a price that is affordable. Competition is keen in the energy market. The independent oil producers play a key role in this country's energy picture. They drill approximately 85% of the wildcat wells. The independent oil producers account for 65% of the new oil and gas fields in this country. The windfall profit tax not only affects the large oil-producing companies, but it places an undue burden on the more than 3 million or so royalty owners. Let's look at the dollars and cents of this. A royalty owner receives approximately $5.80 on a barrel of oil that sells for $40. With the imposition of the windfall profit tax, a royalty owner would pay approximately $2.40 on any income derived from the sale of 1 barrel of oil. Any profit to the royalty owner is nearly cut in half under the current windfall profit tax structure. This takes away any incentive for more production on the part of the well owner, as the royalty owner's tax bracket increases within the current structure of the Windfall Profit Tax. In addition, Mr. Speaker and my distinguished colleagues, this tax would place an unnecessary regulatory burden on the oil industry that is already overregulated and overtaxed. The costs of complying would be enormous to all concerned. Everyone in this chamber knows that the American people are tired of taxes, tired of regulations, and tired of excessive controls meted out by Congress to the private sector. Congress must act now to answer the will of the people. Congress must act now to eliminate this unnecessary tax.